Okay, so we are going for the question series for the compromise, arrangement and amalgamation of the company. Okay, let me share the notes. The PDF note is already available in my Telegram channel, so I'm going to continue, guys. Okay, so this is a question which is related to, in context of the judicial ruling in the matter of merger, answer the following: where the transferor company is justified in excluding asset held on lease and the license agreement from those transfer to the transferee company. The given problem relate to section 232 of the Companies Act. We all know this. Okay. So as per section 232, an application may be made to the tribunal under section 230 for sanctioning of compromise or arrangement as it may have shown to the tribunal. For that, the, as I told you, this point is going to be asked, section 232. Okay, that the compromise or arrangement has been proposed for the purpose or in connection with scheme for reconstruction or merger or amalgamation. Second, the scheme is the other under the scheme what the whole or any part of undertaking, property, liability. Okay, it's going to be transferred by transfer company to transferee company, any one company. Okay, again the same thing, the whole or any part of undertaking of transfer company is going to be transferred to one or more transferee company. Okay, that is to be written here. Now the issue raised in the given problem is same is the issue raised in the Supreme Court in the Hindustan Liver Employees Union versus Hindustan Liver Limited. So what was the case? Let's discuss it. Okay, a scheme of amalgamation provided for the transfer of all the asset. Okay, when the compromise arrangement is done, all the assets, all the properties, all the liabilities to be transferred by the transfer company and to the transferee company. We know this, but there are some assets, okay, which is to be excluded. Okay, those assets in which the transfer company have no right, that should be definitely excluded. If the transfer company have taken the asset on lease, so tell me, is it the asset of that company, the transfer company? Nahi, that is should be excluded. This is what the question is asking us and we have to reply. Okay, so the scheme of amalgamation provided for the transfer of all the properties, all the asset, undertaking and liability of the transfer company to the transferee company. ठीक है, however there are three properties which were not to be transferred to HLL under the scheme. The scheme of amalgamation was objected on the various ground, including the ground that the scheme was malified, since this property was excluded from the asset to be transferred to the transferee company, and there it was held by the Supreme Court that these three property were being used by the Tomco purely under the gratuitous license with no enforcement right. हाय मैम, जो केस स्टडी आप नोट्स में है वो सब स्टडी मैट के हैं ना? सब स्टडी मैट के नहीं है गाइस. आई रिफर सम टीचर्स बुक, ओके, एंड अदर सम आर फ्रॉम मुनीश भंडारी सर्स बुक. ठीक है, सम आर फ्रॉम स्कैनर. ओके, सो अभी अपने मॉड्यूल में से नहीं है. दिस इज प्रीवियस ईयर क्वेश्चन पेपर आज इन CA and CMA exams. Okay, hi Prashant. So let's continue. So number 4, so what they are saying that कि हाँ, hold such property, Tomco has no right property authority to privilege over such properties. The owner of such properties could at any time revoke the permission to use give to Tomco. If the owner of this property choose to get back at any time, ठीक है, so they have to give the asset back, right? So they have no, basically the transfer company have no possession, no right over those company. Okay, so this is what they are saying. Okay, so there are some things which we have to complete, which the transfer company have to exclude. So this is all about written in the discuss in the Hindustan Liver Employees Union versus Hindustan Liver Limited. Okay, so let's go for the other point. Does next question of the scanner of December 2016, page number 13.197, I have mentioned there. Does the scheme of compromise and arrangement under the Companies Act 2013 require approval of preference shareholders? So this should be cleared, guys. The term member include the preference shareholder. Further, the preference shareholder are class of members and their right may be affected differently in proposed scheme or arrangement. Hence, approval is also required. If the tribunal direct the separate meeting of preference shareholders and equity shareholder, then the scheme should be approved by requisiting majority in both such meeting held as per the direction of the tribunal. Okay, so this you have to mention again. Let's go for the other question of the scanner. Okay, question, this is from December 2019, page number 13.199. Is it mandatory to obtain the regulatory approval for scheme of compromise arrangement as per the scheme? Do you remember notice के बाद क्या करना, documents not the notice and documents should be sent to whom? Regulatory authority. And who were the regulatory authority? The what the do you remember the points, guys? If not, you are not doing the right revision. Okay, so yes, they are again the central government, the income tax officer, the registrar, the SEBI, the recognized stock exchange, right, the competition commission of India, the liquidator, okay, and any other which is prescribed. Okay, hope so I am audible, guys. Okay, so these are the regulatory authority, and let's go for the answer. Notice to be sent to the regulator seeking the representation, selection 230 subsection 5 states that the notice under subsection 3 along with all the documents in such a form as may be specified shall also be sent to central government, the income tax authority, the Reserve Bank of India, the Security and Exchange Board of India, the registrar, the representative stock exchange, the official liquidator, and and there are some more, which is Competitive Commission of India establishment under subsection 1 of section 7 of Competition Act 2002 if necessary, and such other sectoral regulator or authority which are likely to be affected by the competition or arrangement, and such require that the representation. Yes, with the once the notice and documents is sent to these the regulatory authorities, they have right to appoint the representation within 30 days. Okay, hanji, from the date of receipt of such notice, failing which it shall presume that they have no representation to make on proposal. So yes, this is mandatory to obtain regulatory approval for scheme of compromise and management. So you have to mention who are the regulatory authorities. Okay, so you have to remember that point. Okay, so let's go for the other question from the scanner, page number 13.201 of June 2017. A meeting of member of Joga Agriculture Equipment Limited was convened under the order of court for the purpose of considering a scheme of compromise and arrangement. अच्छा, do you remember वो point कि compromise and arrangement कहाँ से क्या condition होता है? Majority of members, right? 3/4 of member, right? जी, okay. So they have mentioned the meeting was attended by 200 members holding the 5 lakh shares. Okay, again 200 members, and 70 were holding 4 lakh share in aggregate value of scheme, 120 holding 90,000 in aggregate voting against. So number first, if for the compromise and arrangement, the majority of members should be there, okay, in favor. So here 70 members who are in favor, which is less than majority, right? 200 ka majority means 101 members should approve at least. Okay, and with that 3/4 in value of majority of shares, and the condition is stating both of the condition should met, not only once. Okay, so there is 2 condition and that is to be met here. Okay, so yes, 120 member holding 90,000 share in value voted against the scheme, 10 member holding 10,000 shares abstained from the voting. So you decide whether we are going to take this 10 member or not. Okay, they are abstaining from voting, so you have to keep in mind. Okay, examine with reference to the relevant provision of the Companies Act whether the scheme was approved by the requisite majority. So under, we are going for the answers. Compromise or arrangement according to section 230 subsection 6 of the Companies Act 2013, the scheme of compromise and arrangement must be approved by a resolution passed with a majority in number, who is representing 3/4 in value of the creditors or the member or class of member, or any case present and voting either in person or by proxy. The majority is dual in number and in value. So guys, first of all you guys have to think this is going to approve or not. ठीक है, if you know answer, ठीक है, so you just have to continue. If you don't know answer तो ये बहुत गलत बात है, because we know the condition already. ठीक है, so let's go for it now. Okay, the majority is dual in the number and in value. A simple majority of those voting is sufficient, whereas the 3/4 is required related to value. The 3/4 value is computed with reference to paid up capital held by the member present and voting at meeting. Okay, in this case 200 member attending the meeting, but only 190 voted at the meeting, and as 70 member voted in favor of the scheme of the requirement related to majority in number, which is 95, is not satisfied. ठीक है, 190 member are participating in the member held. Among 200 we already say 10 were abstaining. ठीक है, among 200 10 were abstaining, which means 190. and what is the 190 का majority? is it 95 what? 190 का majority 95 से ऊपर होना चाहिए, 96 should be there. ठीक है, 96 member of the creditor should approved. ठीक है, majority, and this 96 or more, ठीक है, member or creditor should have at least 3/4 of value of shares. ठीक है, so yes, this condition is not at all satisfied. Okay, so 190 member who participate in the meeting held 4,90,000 share, 3/4 of values, which work out 367,500, while 70 voted for this scheme held 4 lakh share. The majority representing 3/4 in value is satisfied. In the instant case, the scheme of compromise and arrangement of Joka Agriculture Equipment Limited is not approved. Yes, as the value of share voting in favor is significantly more, the number of member voting in favor do not exceed the number of member voting against. So we all know that majority of member should be there. With that, the majority member in favor should have at least 3/4 of value of shares. ठीक है, okay, let's go for the other question guys. Okay, which is related to June 2023. Question page number 13.202. ABC Limited is a public limited unlisted company with 50 crore equity share of 10 each. It has taken over 70% of the equity. Case study. ठीक है, 70% of equity of the company called BCG Limited, which is listed company with equity company, or 20 crore rupees 20 crore divided into the share of 10 each. ABC Limited and the BCG Limited has decided to merge. Okay, so the CEO of the BCG Limited has the following queries which you have to answer. Is the decision to merge is in order necessary? Yes, right, we already read the condition. So let's go for the answer. Yes, the decision to merge is in the order. The company are free to merge with the consent of shareholder and by passing the procedure prescribed under the law, right? Yes, it will not fall under special category merger under section 233 of the companies. Yes, the scheme is necessary. Yes, let's go for the second point, second question, same question ka. Is the merger to be approved by a member of each of the company? Yes, majority of member, and that majority of member should have 3/4 of value of share. Yes, so the answer of second point, yes, the scheme has to be approved by 3/4 of majority of the shareholder in value. Yes, let's go for the third point. What happens if few shareholder do not constant? So the dissenting shareholder they were talking about, okay, have to accept the decision of the majority. Yes, so then only the compromise arrangement is going to happen. Let's go for the fourth. Does require order of NCLT? Yes, it's require approval of NCLT because the transfer company is listed and SEBI regulation have compiled with whatever application. So this was all about this section, the chapter compromise and arrangement. Let's go for our last chapter and I'll be quick guys in this case. Okay, so what is this section? Okay, एक बार मैं I'm going to share again the notes in my Telegram channel guys. इंक्वायरी इंस्पेक्शन वाला है, इंक्वायरी inspection, inquiry and investigation. We are going for in this chapter. Okay, so let me check the notes. Give me time. Okay, I got it. I just shared it. Okay, now you can see this inspection, inquiry and investigation. So I am going for this chapter, okay, where the power of registrar to call for information or document under section 206, whether the registrar is going to have such any power, if yes, what are and what is the condition. Number first, the registrar may call for the information and documents to the company by written only, okay. So the company is liable to furnish the information and document which is being asked by the registrar within a reasonable time, which is the reasonable time is going to be provided by the registrar in the notice itself, okay. Now the duty of the company to furnish the information and document along with the officers, employees are liable to furnish all the information documents. Now question to you is, guys, whether the past employee is liable to furnish the documents and information related to company. Yes, but the written notice should be served to the past employees or the past officer. There was a question also, okay. So you have to read this. This was the power of registrar, but there are some power where the registrar can go to inspect book of accounts. They are the power of registrar to inspect the book of accounts. That is going to be when the information or the explanation is furnished to registrar. If not furnished to registrar, okay, if it is not furnished to registrar within the time specified by the registrar, okay. Or second point says, if the information and the explanation provided by the employees, by the company, it's not adequate. Yes, if it is inadequate, again there is a power of registrar to inspect the books of accounts, okay. Number third says about the the company doesn't disclose the full and the fair statement of the information which is required. So there are 3 points says, okay. In this case only the registrar having the power to inspect the book of accounts, okay. So question iska aaya hai, scanner mein hai a question, okay. So let's go for the other point, power of registrar to call for information or carry out inquiry. The registrar may carry out such inquiry as he deems fit after providing the company a reasonable opportunity of being heard. The business of the company is being conducted in fraudulent, unlawful, or it's not comply with the provision, then only they can go for it. And before exercising the such power, the written order is to be served. Yes, okay, opportunity of being heard is given, okay, written order is to be served. And what is going to be contravention punishment for this section? Fine is up to 1 lakh and additional fine up to rupees 500 per day if it is continuing. And with this, the section 206 is saying there is a power of CG to do the direct investigation of book by the inspector, and again power of CG to authorize any statutory authority to carry out the inspection. So this was all about the section 206, where the registrar may call for information and documents, okay, to the company, okay. So the company is liable to furnish the documents and the information which is being asked by the registrar in the specified time. And if it is not specified, if it is inadequate, or if it is not fully disclosed, or it's not true in value and all, in that case the registrar can go for inspection, okay, of book of accounts and documents, okay. Then again, the central government can also authorize some other person to go for inspection under section 206 saying about, okay. With that, again the central government have power to authorize some other person for the statutory authority, okay. This was all about the 206. Let's go for 207 section, conduct of inspection and inquiry, okay. Once the registrar inspector call for book of accounts and other documents under section 206, it is duty of director, other officer and other employee of the company to produce all the documents, okay, to render all the assistance which is connected with inspection, okay, or make or cause to be made copy of book of accounts or any other book, okay, make identical mark on that book of account, okay. And with that, the discovery or and production of book of accounts and other documents. So summoning and enforcing, these are the common points which we know, okay. So I'm not going in depth, okay, ये बहुत common है, examining them, oath, inspection of book of accounts and other, okay. So this is the what they have to cooperate with the inquiry which is done by the registrar or the inspector. Okay, they have to render all the assistance, they have to give all the information, they have to show the all book of accounts and documents and all. Okay, so this is related to conduct of inspection by whom, by the registrar or the inspector under section 207. Let's go for report on inspection under section 208. 206 was telling about the inspection by whom, by the registrar have actually power. Okay, but there are some cases, okay, when they are going to exercise that power. 207 is of conduct of inquiry by whom, by the registrar and inspection. 208 is of the registrar, the report of inspection is to be sent to the central government by whom, by the registrar and inspector, definitely. Okay, and the report of the registrar may include recommendation that further investigation into affair of the company is necessary or not. Let's go for the section 209, says about the search and seizure. Now, when is this search and seizure going to happen? Where the registrar or the inspector has a reasonable ground to believe that the books and the people of the company is likely to DMAFS. Okay, what is this DMAFS? Destroy, mutilate, alter, falsify and secreted. Let me say it again. 209 is of the search and seizure, when where the inspector or the registrar has a reasonable ground to believe that the people and the book of account, the documents of the company being destroyed, mutilated, altered, falsified, secreted. Okay, in that case they may exercise the following power. What is the power here? They can enter and seize, search the place where the documents are kept. They can seize such book and paper, but there is a time limit again that could come in MCQ form. Then obtaining, they can only go for this thing for search and seizure once they obtain an order from the special order for the seizure of such books and paper. Okay, so yes, so they have to return the seized book and paper within 180 days. Okay, within 180 days from such seizure. But whether this the return of these books can be extended, yes, for the 180 days by written order can be extended, and the registrar inspector may take copies of extract from the place and place identification marks and all. Okay, this was about the section 209. Let's go for section 210, investigation into affair of the company, where the central government, yes guys, it's going to be important, where the central government is of opinion that it is necessary to investigate. Okay, on the receipt of the report of under section 206, 208, okay, of whom registrar or the inspector. Okay, this is the first point. Second, special resolution passed in the company. Okay. Third, in the public interest. In this case, the central government is of opinion that the necessary investigation into the affair of the company. Again, I am saying first, registrar on behalf of report of 208, okay, which is sent by whom, by the registrar and the inspector, right? Second, the special resolution is to be taken or in favor in public interest. Now, what is going to be the duty of central government to order investigation, where the order is passed by the court or the tribunal. I'm talking about section 210, guys, this is important. So where the order is passed by court or tribunal, CG shall order the investigation to affair of the company. In this case, CG may appoint one or more investigator, investigating officer. Okay, so this was all about section 210. Let's go for section 211, which is again important. Serious fraud investigating officer. There was a MCQ question asked. SFIO, what is the full form? So yes, CG shall establish an office to investigate fraud relating to company by issuing notification. Yes, with that, composition of this serious fraud investigation officer shall be headed by the director, experts and other officer, and they shall consider the number of experts as the CG may deem fit, and they should have the ability, integrity and expertise in the following field. So what are the following field we should know? So I have made a shortcut, which is BC, FC, IT, TL. Again, let me say it, BC matlab wo nahi, okay, BC, FC, IT, TL. So let's go for the full form, guys. B B is banking, C is corporate affair, ठीक है. F is forensic audit, C is capital market, IT is information technology, T is taxation, and L is law, which is combinedly, let me say, BC, FC, IT, TL. ठीक है. Good way of remembering the answers. ठीक है. So these experts have these person who is appointed by the CG should have ability, integrity, and the experience in these field. So let me say it: BC, FC, IT, TL. Okay. And any other field as may be prescribed. So this was all about the 211 section. Let's go for section 212, guys. Investigation, again this is important, continuation ही उसी का. Investigation into affair of the company by SFIO. Now the power of CG to order investigation into affair of the company by SFIO. Central government will give an order to whom? To SFIO to conduct the investigation on what basis? Number first, we know this, okay? We have already read under section 208 on basis the report which is sent by the registrar or the inspector. Second point is on the basis of special resolution passed in the company, okay? Third, public interest, and fourth, which is new, which is if department of central government or the state government is saying that, in that case central government again will investigate, will give power to SFIO to investigate into affair of the company. So there are 4 points under section 212 says about the serious the central government can authorize SFIO. Okay? Number first, report where the report is sent by the registrar and the investigator, special resolution is passed, public interest, or the department of CG and SG. Okay, hope so this point was clear. Yes, SFIO shall conduct the investigation and submit its report to central government within such period as may be specified. And officer and employee provide all the information, same thing, explanation, all the assistance given to the investigating officer. Yes, let's go for the other point. Offense to be cognizable and the condition for release on bail. No person shall be released on bail unless the public prosecution has given an opportunity to oppose application for the release. Okay, so no other person can release on bail. So if the public prosecution have object, then the person won't get any bail. Then let's go for some other point. The special court to direct may release on bail if a person who is under the age of 16, women, sick or infirm. In this case only, ठीक है. For a male, they have समझ गए ना. हाँ, ठीक है. Let's go for the other point. The interim report shall submit to the central government. Yes, the investigation report shall be submit to the central government. If the investigation is compulsory, but if the interim report is asked by the central government, then it is to be sent to the central government as per directed by the central government. Okay, yes. Let's go for the other important question, which is under section 213, investigation into affair of the company on order made by tribunal. Order made by tribunal, what are they saying? Whether tribunal point is covered? Yes. You know what, tribunal and court points was already covered under section 210. Go back, guys, and check whether this point is given or not. As the investigation into affair of the company under section 210 was done by conducted by whom? Inspector, and the central government is going to, if the central government is of the opinion that the necessary to investigate into affair of the company, again किसके बेस में होना चाहिए था? सेक्शन 208 रजिस्ट्रार एंड इंस्पेक्टर रिपोर्ट, स्पेशल रेजोल्यूशन, public interest. With that there was some other point where the order is passed by the court and tribunal. Okay, Hanji. So this is all about the section 213 which we are going to start. So yes, there is a point where the tribunal may order for investigate, okay, to the central government. Okay, so the central government shall order an investigation of affair of the company if the tribunal make an order that the investigation to affair of the company is required. But when the tribunal think the investigation is actually required, yes, there are some condition. The members are eligible to make the application to the tribunal, but whether tribunal will go for it? Yes. First point is that tribunal either go for suo motu if the tribunal think something is happening, is conducted in the company, mismanagement of the company, which is against the public interest, then definitely the tribunal can take the action, okay, by own suo moto. Second, where the members have filed the application. So there are some conditions where the members are eligible to file the application to the tribunal. Again, this section 213 is important, guys, okay. So this may come in form of what are the eligibility or the questions, okay, which come in eligibility of members who can file the application to the tribunal. So the member who are going to eligible to make application to tribunal, this is divided into two part. Number first, where the company is having the share capital, where the company is having no share capital. When the company is having share capital, either 100 member or one or more member holding 10% of total voting power, whichever is less, can go and appeal the application to the tribunal. Okay, let me say it again. 100 member, one or more member holding one tenth of total voting powers. Okay, इतनी बात समझ में आ गई? हाँ जी. So what about the no share, where the company is not having share capital? 1/5 of total number of member are going to be eligible. ठीक है, who are going to be, who is basically eligible. So yes, 213 is about the investigation into affair of the company on an order made by the tribunal. Yes, हाँ जी. But the central government shall order the investigation if the affair of the company, ठीक है, when the tribunal make the order, but either tribunal is going to either make the order by its own suo moto or on the basis of application received by the member on the eligibility. 100 member or the 10% or one or more member who is holding 10% or more of the total voting of powers, ठीक है, total voting power, whichever is less, to be taken, to be considered for the application, ठीक है. And second, if the company is not having share capital, but for the total members, ठीक है. Yes. Now, when are the condition when the tribunal can go for itself? I mean, when they think there's something mishappening conducted in the company. So the condition is that the tribunal is satisfied that any of the following circumstances exist, where the business of the company is being conducted fraudulent purpose, unlawful purpose, or oppressive of any of its member, or with the intent of default in its creditor, member, any other person. And last point, person connected in formation management of the company, ठीक है, which let me say formation management of the company is FMC, ठीक है, and which is related to fraud, mismanagement and misconduct, which is FMM, ठीक है. So which is related to formation, mismanagement of the company, and fraud, misfeasible and misconduct. Okay, so this is where the company, where the tribunal can go for the order to whom? To the central government, guys, ठीक है. Fraudulent, unlawful, oppressive, or in intent to default of creditor, member, any other person who is connected with the formation management of the company, the fraud, the misable and misconduct. Okay, this is important, guys. Okay, let's go for section 214, where the security for payment of cost and expenses of investigation. So where the company's turnover is up to 50 crore, then the amount of payment for the expenses for the investigation, they have to pay 10,000. Where it's exceed 50 crore to 200 crore, then 15,000 amount is to be paid by the company. Then again, if the turnover is more than 200 crore, then the amount of security is to be deposited 25,000. Okay, 215, as there is no as much written there, firm, company, body, corporate or the associate not to be appointed as inspector. That's all in that part. Okay, let's go for the other important section, which is 216. Earlier we read about the investigation, ठीक है, where the tribunal can go for central government, उससे पहले हमने पढ़ा. Now we are going for 216. Again, this is important, mark this important, guys. The central government may investigate of membership of the company, ठीक है. Again, central government either suo moto or by tribunal, if the order is passed by tribunal, shall appoint one or more inspector by the order direct that the investigation into members of the company. The purpose for determining these people who are or have this financial interest in the success or failure of the company. Second, they have the control of the policy of the company, basically materially influence इसको कह सकते हैं. And third, who have or had the beneficial interest in the share of the company. So let me say the purpose for determining the true person is going to be what? Who is or have been financially interested in the success or failure of the company, who has the control of the company, the material influence, let me say, and last we have the beneficial interest in the company. Okay, this was all about this part, and this is important guys, mark it important. 216. Let's go for 217, which is easy. Take a procedure and power etc of the inspector. Duties of officer in the employees to produce book and render the assistant. All the officer and the other employees and the agent, including the former officer employing the agent of the such body corporate or a person, they basically have to preserve the book and produce the book. They have to give all the assistance connection which is connected to investigation to the inspector. Okay. Now same thing, they can retain the book for up to 180 days, and they can extend the time period by in written, okay, which can be extended upon 180 days further. So this could be the question asked in MCQ form. Okay, what is examination? Or this is to be an inspector may examine an oath of any person. Prior approval is to be taken here by the central government. These are basically very easy and we all know the same thing. Okay, oath lena hota hai, discovery and production of book and accounts, they have to give all of the information to the inspector, okay, while in investigation. There is some punishment for the contravention if any of the director or the officer disobey the direction which is issued by the registrar or the inspector. In that case, imprisonment is going to be up to 1 year, with that fine is going to start from 25,000, which could be extended up to 1 lakh rupees. So this is a different thing which you have to keep in your mind guys. Okay, but with this there is more penalty, more contravention if it is related to the above one was for the director and the officer if they disobey, and if any person fails without reasonable clause to produce the information, to produce the inspector book of accounts document, to furnish any information, they fails to do so, in that case imprison up to 6 months and fine of 20,000, 25,000, which may extend up to 1 lakh. So in this case 6 month imprisonment you have to keep in mind. Above there was 1 year, and further 2,000 rupees for every day if it is continuing the contravention is continuing. Okay, so this is all about this section guys. Let's go for the other important section, which is section 216, 218. Okay, so what is this temporary protection of employee? ठीक है, okay, whether company intend to discharge or punish by way of dismissal, suspension or reduction in share. So can I say DSR by way of any change in employment, okay, of employee by dismissal, suspension or reduction in rank of that employee. But why the company is going to do so, where the as we all know this chapter is related to inspection inquiry, okay. So any person, any member have given information to tribunal or central government. So once the company get to know that this person have informed them, so the company will go against that person definitely, because the person have given all of the information to the company. So all of the major person is going to take the power, basically they have the power. So okay, and they will, you know, either they will dismiss that employee or suspend that employee or can reduce the rank of that employee. That's why this section was formed, for the temporary protection of that employee who have given the information to the central government, right? And on his basis the investigation was conducted. Okay, so yes, so during the pendency of any investigation under the section, now I'm going to say the section name and you have to remember the content which was related to that. Okay, so during the pendency of any investigation under section 210, 212, 213, 216, 219, 219 don't worry, I haven't done yet, ठीक है, मतलब अभी तक नहीं पढ़ाया, so don't worry. So what is about 210? Remember central government. Okay, what is about 212? SFIO, remember? हाँ जी. 213 was of tribunal wala. Okay, 216 was of membership, and 219 which we are going to read just after this section, which is of related part companies. Okay, so the temporary protection of the employee where the company intend to discharge or punish by way of DSR, dismissal, suspension, reduction in any rank of employee. Okay, हाँ जी. Okay, by change in term of employment of his disadvantage during the investigation under section 210, 212, 213, 216, 219. Okay, you have to remember each and everything, and there was a question being asked. Okay, scanner में questions मिलेंगे आपको. Or the second point, during the pendency of any proceeding against any company concerned in conduct, management of affair of the company under chapter 16, section 241 to 246 of prevention of mismanagement वाली बात है. Okay, so where before discharging or punishing that employee, the company shall make application to tribunal. Okay, हाँ जी. If the company do not receive any response or any notice from the tribunal, okay, any order from the tribunal, then the company can proceed of by doing DSR, dismissal, suspension, reduction of that particular employee. Okay, but what if the company receive the objection or the order from the tribunal, okay, and the company is not satisfied by the order of tribunal, then again they can go and appeal to appellate tribunal within 30 days of the receipt or communication of the tribunal. Okay, so lastly, one thing, the order will be final and binding of the on the company by whom? By the appellate tribunal. So whatever the appellate tribunal is going to take the decision, that is going to overlap everything. Okay, whether that is in favor of employee or it's not in favor of employee, so that is going to be the final order, final thing which is going to be taken by all of the employees, directors and all. Okay, so this was important section, guys, 218. Let's go for another important section, 219. Inspector to conduct investigation to affair of the related party. Inspector appointed under 210, 12, 13. Sorry, it's considered necessary for the purpose of inspection for whom which is related to investigation affair of the company, any other body corporate which has or that any relevant time being company or holding company subsidiary. Basically ये वही point है, every point is similar. ठीक है, by the position of managing holder or board of directors of the nominee, each and everything should be, they have to mention which is related to related party. ठीक है, okay, let's go for the other section. Section 220 says of the search and seizure, same thing. ठीक है, where destroy DMAFS वही 180 days. ठीक है, and the inspector have right to take the access the copy, take the copies, make the identical mark on it and all. Okay, let's go for the other. That was all about that section 220. Let's go for the other important section, which is the section 221, freezing of the asset of the company on inquiry and investigation. So here the tribunal have power to freeze the asset of the company. Freeze, yes, freeze के साथ साथ there are some other points also. ठीक है, where the removal, transfer, disposal of fund, asset, properties of the company. Okay, but this freezing time period shall not exceed 3 years. इतनी बात समझ लो, MCQ फॉर्म में आ सकता है under section 221. हाँ जी, so for there is going to be some punishment for the contravention, that is fine for 1 lakh and that is going to extend up to 25 lakh. Again, for this was for the company, and what is for the employees? Fine 50,000 extend for the 5 lakh rupees, guys, and with the imprisonment of 3 years. Okay, okay, so let's go for the section 222, imposition of restriction upon the securities. There's some punishment basically which you have to keep in mind. So for the company, that is going to be 1 lakh and maybe extend up to 25 lakh. For the officer, that's going to be 25,000 and it's going to be extend up to 5 lakh and imprisonment of the 6 months. That's it. Section 223, ये we know basically what is this. ठीक है, this is not as much important, but we have to keep in mind कि as the inspector have to submit the interim report to the central government if it is directed. We all know this. ठीक है, so this is not as much कि बहुत difficult है, it's very easy, and the inspector shall submit the final report to the central government. Okay, so copy of report of this inspector can be obtained from the central government by member, creditor or any other person who is likely to have an effect. Okay, let's go for the another last important section, which is section 224, and it is important, guys, because question आया हुआ है इससे. Let's go for it. Action to be taken in pursuance of inspector report. On the basis of report which is given by inspector under section 223, the central government is going to take the final action. Okay, so it appears to CG that any person is guilty or the officer which is criminally liable, the CG may prosecute such person for the offense. Okay, hanji. With that, the company may liable to wind up on the basis of a report which is given by the inspector. Okay, so on basis of inspector report, that could be possible wound up of the company. And last, recovery of damage for FMM fraud, misable and misconduct in connection with promotion, formation or management of the company. So this was all about this part, guys. And let me say the important part again. 224, definitely section 224 is important here. With this 221, freezing of the asset of the company is important here. 219 is important. जो भी मैं बता रही हूँ, there is a question which already covered, ठीक है, which is being asked in previous question papers, previous years, ठीक है. So these are from these particular section. So 219, yes, this is important. 218, temporary protection से question आपको इन सब के मिल जाएंगे scanner में. Okay, with this yes, 216, investigation of membership of the company is important. Yes, guys. With this 213, investigation of affair of the company on order made by tribunal is important. And SFIO 212, it's important. Okay, 210, investigation affair of the company by central government is important. Okay, and बाकी सब तो बहुत छोटे हैं, and it's very easy. Okay, let's go for some questions, guys. Same study now note में have mentioned some questions. ठीक है, so you guys have to read this, the question first which I have mentioned here, ठीक है, and it's super easy. Same thing, but whatever I told you, ठीक है, which is one is related to the, I guess, registrar empowerment, ठीक है, the power of registrar 206 के under you have to read it, guys. It's super easy. Basically, why I have taken the photo of a question, because we should know how to quote, to write the answer in the when question is being asked, ठीक है. We really don't know how to frame the answer, so this is the language. Okay, you have to read it, it's very easy, just थोड़ा proper way में quotation होता है. Okay, let's go for the last question, ठीक है, which is from the scanner, which is of June 2023, page number 13.187 from the scanner. Okay, a group of shareholder of MSK Limited made a complaint to the concerned registrar of the company that the business of the company is being called on for the unlawful and a fraudulent purpose, and file an application to inquire into the affair of the company, referring to and analyzing the provision of the Companies Act 2013, decide whether the ROC has what has the power to order the inquiry into affair of the, yes, under section 206 we know that. Yes, let's go for the answer. Yes, the ROC has power to order for the inquiry as he deemed fit after providing the company a reasonable opportunity of being heard into affair of the company. He is satisfied the representation made to him by any person that the business of the company is being carried on for the fraudulent or unlawful purpose or not in compliance with the provision, है ना. तब in that case ROC can go for the inquiry. Okay, let's go for the second. If yes, state the procedure to be followed by ROC. Is there any procedure? Yes, they have to write, they have to give a notice in a written, ठीक है. Orally, if they have said that to give the information or to furnish the documents, that is not going to valid. So yes, with that the employees are liable to give all the information related to book of accounts and documents of the company. With that, past employees are also eligible for that, but for that the ROC have to give the written notice, then only the past employees would furnish the information to the ROC. Okay, this was all about this, but with that opportunity of being heard is to be given. Okay, yes, let's go for the third point, whether the inquiry should be pursued by ROC in case the complaint is withdrawn by the same group of shareholders subsequent to the order of equity inquiry. The answer is the inquiry can be pursued by the ROC in case of complaint is withdrawn, yes, by the same group of the subsequent the order for the inquiry under the Companies Act. Yes, we know this also. And let's go for the last point of same question, whether the CG has power to direct the ROC to carry out the inquiry. Yes, what was the section, guys? Do you remember the section? If you know, comment. ठीक है, if you don't know, बहुत गलत बात. So yes, the CG have power, okay, and if the CG is the satisfied circumstance so warrant, direct the registrar for the purpose to carry out inquiry under section Companies Act 2013. So this was all about this, guys. So yes, please read the question just before, which I have not covered. You guys have to read it, okay. I have left it for you. Just see the formation of answer, the presentation of the answers, okay. And it's very easy, it's super easy, guys, it's not that difficult. So this was all about 3 chapter we have completed: prevention of operation and mismanagement, compromise arrangement, and inspection inquiry, and with that some questions, okay. So hope so you get something, okay. But yes, I'm not that much good in live, guys, you can see. Okay, ठीक है, but ठीक है, we have no other option with us. So we'll meet in our tomorrow's class, okay, and at same time, that's going to be 7, approximately 8:30 to 9, okay, and I'll give the information in my telegram channel. But हाँ, आज मैं थोड़ी लेट हो गई information बताने के लिए, but I'll keep these things in my mind, okay. So we'll meet tomorrow, and let's do our revision and complete our revision. तब तक के लिए पढ़ते रहो, मस्त रहो, खुश रहो. To this, guys.